Hello, everyone, and welcome to the Bar Association of Montgomery County and the Metropolitan Washington Employment Lawyers Association webinar, Montgomery County's updated human rights law, new workplace provisions, enforcement priorities, and best practices for trial. I'm Scott Oswald. I'm MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, we have an opening remarks from Tom DeGonia, President of the Bar Association of Montgomery County. Tom?
Thank you, Scott, and welcome to everyone. On behalf of the Bar Association of Montgomery County and our almost 3,000 members, I want to welcome everyone, and we're very excited to partner with the Metropolitan Washington Employment Lawyers Association and Scott and his group. I think this is a great example of some of the partnerships that we engage in here in the Bar Association with our affinity groups and specialty bars. And I think this is a great example of the ability that we have to bring together people who are truly at the top of their profession, the decision makers, and our bench. And for those of you who are not members of the Montgomery County Bar, I'd certainly encourage you to come in, tune in, check us out, sign up, and find out what a wonderful place Montgomery County is to practice. I think you're going to see that when you hear from the practitioners, when you hear from Judge Rubin, and when you hear from Mr. Stowe, what a wonderful place Montgomery County really is to practice. And we'd welcome you. Again, thank you. We appreciate the partnership with MWELA and look forward to a fantastic program today.
Hey, Tom, thanks so much. Okay, now to our speakers. Cathy Harris is a co-manager of the firm of Kator, Parks, Weiser, and Harris. Cathy represents employees in discrimination matters in state and federal courts. In 2010, Cathy was the Metropolitan Washington Employment Lawyers Association Lawyer of the Year. Tom McCally is a lead partner at Carr, Maloney's Employment and Labor Law Practice Group, where he represents employers in state and federal courts. In 2019, Tom was the District of Columbia Defense Lawyers Association Lawyer of the Year. Jim Stowe is the director of the Montgomery County Office of Human Rights. Jim has led the office since 2008. Jim is the former president of the National Association of Human Rights Workers and the International Association of Human Rights Agencies. The Honorable Ron Rubin is an associate judge on the Montgomery County Circuit Court since December of 2005. Judge Rubin has served on the Maryland Judicial Conference, Civil Law and Procedure Committee, and the Business and Technology Case Management Subcommittee. I'll take your questions throughout our program. Just use the Q&A feature at the bottom of your Zoom screen. First, we're going to begin with Cathy and Tom giving us a snapshot of Montgomery County's updated human rights law. Cathy?
Thank you so much, Scott, and thank you for having us all here for this presentation. So I guess I have the honor of having proposed this legislation to one of my Montgomery County Council members, Will Jawando. And before I go through the basics of the new law, I'll just tell you how this happened. So in 2019, in the summer, I was reading an article in the New York Times in the morning, as I usually do. And to my surprise, New York State had passed a new law that improved the standard of proof for harassment cases, and sexual harassment in particular was their focus, lowering the standard of proof from severe and pervasive for hostile work environment cases to something that's more than a mere petty slight and so forth. So I'm reading this article and thinking, why don't we have that here? And I got to my office, told my law clerk, here's your summer project, get this passed. So poor Stefano didn't know what I was talking about, read the article, drafted a letter to Will Jawando, and off it went at the end of the summer. It took us some time. And to my surprise, Mr. Jawando called me and said, you're the only person to send me proposed legislation by snail mail. This was very well put together, we're going to go with it. And it took some time and the law passed. So if you have ideas for legislation and you think we can improve things in our jurisdiction, I highly recommend snail mail. Okay, so the new law is the human rights in Chapter 27 of the Montgomery County Code. Discriminatory employment practices in Section 27-19. In Montgomery County, we have no limit on employer size, company size. It's anyone with one or more employees in the county, either for compensation or as a volunteer, very broad coverage. Employee means any individual employed, and the protected basis are very broad as well: race, color, religion, ancestry, national origin, age, sex, marital status, disability, sexual orientation, gender identity, family responsibilities, and genetic status. So that's the basics under the human rights law. I'm going to move over to Tom, and next slide, please.
Thanks, Cathy. And thank you for getting this passed. It's probably going to mean a lot more business for my firm. But turning to the damages of the Montgomery County statute, there is no cap on actual damages, lost wages, and other actual damages. A $500,000 cap on punitives. That point there higher than the cap under Title VII. So another reason to file in Montgomery County. Attorney's fees also available. So there's no difference between this and bringing it under Title VII if you're the prevailing party. Any person can pursue a civil action under the statute, but they first must file with the agency, and it must stay with the agency for 45 days before they can take it out and file suit in circuit court. There is a 2-year statute of limitations to file in circuit court, which is a fairly long period of time. So that leaves a lot of leeway for people either to stay with the agency or go ahead and file. And then finally, Montgomery County, like all other FEP agencies in our region, they have a work sharing agreement with the EEOC. I doubt there'll be much work sharing now with the new standard because the EEOC, their standard is severe and pervasive. So we'll see how that plays out and whether or not they will seek to approve any decisions from the Montgomery County agency. But with a different standard, I would expect there's not going to be a lot of EEOC involvement, but that remains to be seen. And why don't we flip to the next slide and back to Cathy.
Thanks, Tom. So as stated, the new law expressly replaces the severe or pervasive element with a requirement instead that a reasonable victim of discrimination would consider the conduct to be more than a petty slight, trivial inconvenience, or minor annoyance. And the point here is that things shouldn't have to get so bad to constitute a violation of harassment under the law for someone to have become completely destroyed. We want to stop harassment and discrimination before it gets to the point where it ruins people's lives. So that's the new standard, and there's as we know, we usually have to prove an objective standard of proof, right? A reasonable person in the victim's shoes, and the subjective standard. Did the victim actually believe that the harassment was more than a petty slight, trivial inconvenience, or minor annoyance? Okay, next slide, and back to Tom.
And just to focus on this new standard a little more in the next slide, the language is there to the right from the statute. Now, keep in mind, this applies not only to sexual harassment, but all types of harassment for any protected reason. So the new standard for sexual harassment, as well as if it's racially based, religious based, et cetera, is this new standard. Now, looking at it, and if you look at B in the bullet points 3, the subjective portion of it is it creates a working environment perceived by the victim to be abusive or hostile. So that's very subjective. That's going to be what the victim says. The second part is a reasonable victim, and this is where you have an objective standard, but I would, from my perspective, it's almost a subjective, but it's a reasonable victim of discrimination would consider the conduct to be more than a petty slight, trivial inconvenience, or minor annoyance. There are no cases. Cathy and I looked at the New York statute prior to the webinar, and there are no cases interpreting its statute yet. And what these terms are going to come to mean will be determined by the case law as these cases move forward. I would say, however, that it was interesting in the legislative history. The county attorney's memorandum pointed to some Fourth Circuit cases that said lowering the standard is almost moving towards a general civility code. And that's, I think, is going to be where the real battle lines are. What do these terms mean? And how do you prove them in court, since we've now moved away from the severe and pervasive standard? I would also raise an interesting issue might be, how is this going to interact with constructive discharge claims? Is that standard going to be changed as well? Or is it going to be the old standard? And we'll see how that bears out in the case law and as these cases come up. But with the new standard, it's a lower bar, as Cathy said in the beginning. I think that means the chances of summary judgment are going to be much less, and it's going to be harder to win summary judgment in a case that gets to that point. As Cathy said, the point of the law is to stop harassment early on. And I think with these standards, and as new training gets rolled out, employers in Montgomery County or who have employees in Montgomery County really need to focus on this new standard in their training and emphasize reporting immediately. Cathy, if you anything you want to add on this slide?
No, we did find one case in New York that was a trial court decision on a motion to dismiss in 2021 that applies the new standard. It's Black versus ESPN. And it does apply the new standard, but to be completely honest, I think that this case probably would have gotten past the motion to dismiss at the severe or pervasive standard as well. So I don't think it gives us any insight as to how the courts are interpreting it. In this case, the plaintiff alleged that supervisor, the plaintiff had a skin condition, some kind of disability discrimination issue, and the guy directly addressed his skin condition, what's wrong with your skin, and then the plaintiff alleged that his treatment of him diminished after that comment, denied a reasonable accommodation request, etc. So, to me, that probably would have, and there was yelling and so forth in the workplace. So to me, that probably would have gotten past the motion to dismiss stage. Whether it gets past summary judgment, who knows, but that's where we are. So that's all I have at the moment. And this is just the remaining aspects of the statute. You can see, again, as Tom mentioned, the reasonable victim standard. And I think we're looking forward to having things be easier at the early stages of resolution now, because the employer and the employee won't be arguing as to whether conduct meets this hurdle of severe and pervasive. So I think there's more opportunities for resolution and getting things, out of the courts and onto the signed on the settlement table, which I'm looking forward to make things easier for people.
Cathy and Tom, thank you.
Yes. Thank you, Scott.
We're gonna, before we turn to Jim Stowe to talk a little about his office, just two quick questions. First for Tom, we got this one off the Q&A. Does the defendant's insurance cover a successful claim? Bernie Solnick asks.
Well, if you have EPLI insurance, it should cover claims under the new standard. It's still a sexual harassment claim. I think we might see carriers taking a harder look when they write in the county, and whether or not with that new standard, there might be some other adjustments they make. But generally speaking, the insurance policies are written in a way that should still extend coverage for claims brought under the county statute.
Thank you, Tom. Cathy, to initiate a claim under this statute, one has to file administratively with the Montgomery Office of Human Rights. Is that right?
Yes, and it's super easy. You can just look on their website. They have instructions on how to do so. I've had my associates call over there and ask questions. Very friendly, very easy, and frankly, you don't have to have a lawyer to initiate that process. It can be done without assistance of counsel, but of course, as a lawyer, I think it's always better to have one helping you. But it's quite simple, and I find that it's not as difficult, for instance, as some of the other jurisdictions where you have to file administrative claims.
That is a good setup for Jim Stowe to kind of tell us a little bit about his office. Jim, can you tell us how your office, the Montgomery Office of Human Rights, is set up? And in particular, the Complaints Division?
I can indeed, Scott. Thank you so much for putting this together, as earlier mentioned, and really excited about being here and sharing with you about what we do in the Montgomery County Office of Human Rights. We are an agency begun, as it turns out, in the early 60s. 1960 was a tumultuous summer here in Montgomery County that led to the creation of civil rights laws in the county. And then a year later, the development of our agency. At that point in time, singularly focused because they only had one or two people actually involved in the process. But thus begun a better than 50-year existence of our agency. We are divided into three primary segments, and one of those include our education outreach segment, where we are involved in trying to share and to distribute throughout the county information about what we do and how we do it and how it impacts our various parts of our community. We have another area where we deal directly in just training and trying to reach out to persons who are involved in the particular areas that we are dealing with, housing, public accommodations, obviously employment, and ensuring then that they are aware of any sort of changes that are occurring within the law here in Montgomery County. And the area for which is most relevant today is our compliance division, where we have our investigatory staff involved in actually receiving complaints, trying to perfect those complaints in terms of whether or not our jurisdiction applies, and then doing, we hope anyway, a very thorough investigation of those complaints, and then rendering a decision for which is upheld by our commission members who are appointed by the county executive and approved by county council. And so that particular area is one for which we try very best to be as responsive as we can to all sides of the issue as we go through. We also, by the way, serve as administrative support to various commissions and boards that are created by county council. They would include the Human Rights Commission, the Committee Against Hate Violence, the Remembrance and Reconciliation Commission, the Interagency Fair Housing Coordinating Group, all part of that particular area. We provide technical assistance and advice and counsel for those particular volunteer bodies within Montgomery County. So that's our structure, Scott, and that is how we hope in a way that we are in fact servicing residents of Montgomery County.
Talk to us a little bit about how a complainant files a complaint with your office.
He or she can certainly do a number of things, and of course, COVID-19 has really sort of restricted some of those avenues of access to our office. Our office, of course, is officially closed to the public, but persons still are able then to file complaints by going online. We have our complaint system and processing particulars on our website. But they can actually go on the website and then download the complaint form and actually send in their complaint. We'll follow back up with a phone call, trying to figure out and find out more in detail about what the complaint is about and how we can assist that particular person in trying to get to the very basis of their complaint, and then supply for them advice and information about how the process will go forward. So at this point, we're talking about, again, you can call by telephone to also share that complaint or inquiry about a complaint. And also, as I mentioned, by virtue of going to our website and downloading the actual complaint form itself.
And Tom talked about the statute of limitations, Jim, of 2 years. Just for all of those that are listening, what's important is that the intake form that one submits to your office, that is not the final complaint, right? Just to let everybody know what the final complaint is as far as your office is concerned.
Scott, is an excellent point, by the way, and that 2 years is person's ability to actually go into court. The statute of limitations for Montgomery County is 1 year from the actual incident itself. And so there's a big distinction there between those two timeframes. But in terms of looking at overall piece, you can actually come Scott, clarify your question a little bit more. I'm gonna make sure I answer exactly what you're asking.
Yeah, so when one files their intake form, let's just say within that year, right? They have to, your office has to then interview the individual and comes up with a final complaint,
Yes.
which then serves as the complaint as of the time that the investigator and the complainant agree on its terms.
Scott, thank you, because I wanted to make real sure that we are addressing this, because this came up very recently, because the actual filling out of the complaint form itself does not, in fact, begin the process. That at that point in time is an inquiry that we got to, in fact, to perfect. We've got to go back and make sure the information is correct, and that we're understanding what the actual potential complainant is actually, again, alleging in his or her complaint. Once that complaint is received by our staff, we have the responsibility then going back and coordinating with the person, and we want to have a signed actual document, a signed form that says, I agree that what I've said to you is what you, in fact, have delineated here on this form, and it does, in fact, represent the ideas for which I have shared with you in terms of my complaint form itself. And then once we have a signed complaint form, then the clock, as it were, begins to run in terms of us having that complaint in our actual charge system. We begin at that point in time, then assigning an investigator, and the actual investigatory process begins at that point.
Got it. Your office has a vigorous mediation program. Tell us about it.
Well, we have, thank goodness, in this community, a number of persons who are eager to help us in this area. We have retired administrative law judges. We have those who are attorneys, those who are engaged in the real estate industry, and others who have gone through a 40-hour training that has qualified them to be a mediator in the state of Maryland. And so these persons are not employed by Montgomery County. They serve in a voluntary capacity. And they then are responsible for assisting us in mediating a number of different issues that come before the Office of Human Rights. One of the things I think is important to note here is that they handle the whole process. Once we assign a given mediator his or her a case, they set up the interview process. They in fact coordinate with those who are involved, both from the complainant side and respondent side. We do offer a facility in our offices that provides the kind of environment to actually convene a mediation session. So that's available, but they may choose, because of the parties' desire, to have that particular session at another location, and we would certainly support that. But at the end of the process, we want to make sure it's objective, it's free of any kind of influence from our office, and so persons truly get a chance to have their grievances heard in a way that's professional, and we believe that is successfully trying to get to some sort of conclusion most of the time.
Are you seeing any trends in your office now in the kind of charges that you're receiving?
It continues to be, of course, employment continues to be obviously the one for which we get the most complaints. We're starting to see more and more complaints that are in the area of national origin, those that are dealing with folks who don't have English as their first language. We have those that are coming up now dealing with disability in the workplace, and the one for which is our our sort of topic for today is sexual harassment. And we actually began to see this several years ago. This is not a new thing for us. And I will share with you that the real issue, and in fact, we shared this in our testimony when this bill came before County Council, that many of those who were, in fact, potential complainants really said to us is that they were in almost a no-win situation in the workplace. Because while these incidences were happening, they were reporting them to supervisors and to management. Nothing was being done by them because they were often said to grow up, be less sensitive about what's happening in the workplace. And so it really was very frustrating for us because, again, we were not able to move those cases along as far as we would like to have done because of those reasons. And so at any rate, that is an area that we are concerned about. We constantly are in this situation where we are trying not to, again, be advocates necessarily for one side or the other. We have to interpret the law. But clearly, this is an area that needs some real attention by employers.
Jim, thank you. Cathy, I want to turn to you. What are the hallmarks from your vantage point of a compelling harassment claim?
So I used to work with an attorney, Josh Bowers, on a lot of sexual harassment cases, mostly against the federal government. And he loved cases that had more than one witness, right? More than one person to corroborate the harassment so that you don't have to hear the annoying he said, she said, Maloney that we hear in a lot of these cases, right? So that it's not one person's word against the other. So that always helps. I think also contemporaneous reporting is useful. And you know, the most wonderful thing these days is the advent of electronic technology, texts, videos, emails. I mean, so much is caught in an electronic trap these days that really helps us prove our cases in a way that was just not possible 20 years ago. So that's very useful. You know, personally, you know, I don't need all that to think that a case is compelling. I like to hear from the victim and what they experienced and what happened. And if it, you know, rings true to me and I believe them, I go for it, no matter what other evidence I have to support it, because I think the more people that come forward and tell their stories, the less we get into this he said, she said paradigm, which I think is really unhelpful for a lot of people, because we know a lot of harassment happens behind closed doors where there are no witnesses. So I think the more people that come forward, the more that bring this to their employer's attention, the better it is for the rest of the cases as well. So I take compelling cases of all kinds, no matter what the evidence.
And Tom, tell us just from a defense perspective, right? When you're looking at the dangerous harassment case, what are maybe the hallmarks there for you that make you say, uh-oh, we have a problem?
Well, the worst is the repeat offender, someone who's had multiple complaints or allegations against them, going to what Director Stowe indicated, that there's a track record that people have been complaining, but nothing's been done. When you have the repeat offender, in almost, I would say 90% of my cases, other victims start coming out. Whether they are current employees or former employees. And then defending those cases, you're not just defending the case, you're defending all the other cases, that you're really kind of behind the 8 ball on trying to catch up with what went on in those matters. Number 2, particularly for Montgomery County, where we have highly educated jurors, the power differential. Many times there's a defense about the person didn't report. They didn't use the procedures. They didn't follow up. They just failed to bring it to a supervisor's attention. When you have a significant power differential, jurors get it. And they understand why that defense, it's not going to work for you. They understand why the subordinate employee did not file the internal complaint, did not take it to a higher level, or go to other managers. And kind of dovetailed with that is when the company is really the alter ego of the harasser, particularly when you have a smaller company and the harasser is the person in charge of everything. Those are very difficult because the evidence that comes out is that that person makes the decisions, makes all the decisions. So those three areas are the ones that they pique my attention. There's a lot more work to do rather than, as Cathy said, the he said, she said, because there's usually a history of prior complaints with the repeat offender that they've either not been properly addressed or someone dropped the ball. But those are the ones that I don't like to see coming across my desk, and we look for conciliation and mediation sooner rather than later.
Cathy, when Tom said repeat offender, I saw you smile.
You know, it's so rare that when you have a case that, you know, comes to my attention or any lawyer's attention, that this is the first time the harasser has ever bothered somebody, right? That is very unusual. So it's really not difficult to ascertain through just the most rudimentary discovery whether there's been prior complaints or other Me Too witnesses who can corroborate what's happened. So, you know, I just don't think that perpetrators stop doing what they're doing until they're made to stop, right? So, and sometimes they keep going on it after that. So that is always an area of inquiry that we have, and it's usually quite fruitful.
Cathy, thank you. Judge Rubin, I'd like to bring in you at this point. Montgomery County has a track system in its civil division. How is track 4 assigned in Montgomery County?
Thank you. I appreciate the time to be here and to answer your question. Typically in our county, to get onto track 4, which means you get specially assigned to a judge and your case doesn't bounce around from judge to judge, you need to indicate a trial time of 4 or more days. What I want to mention to folks is when you're thinking about amount of time for trial, don't forget that your trial includes jury selection, instructions, and arguing about the verdict sheet. Usually lawyers just say, okay, it's a 2-day case because that's for the witnesses. In cases like this, I think that jury selection is going to take more than the usual amount of time. So please include that in your thinking about time of trial. But 4 days or more usually gets you track 4.
Judge Rubin, thank you. Tom, back to you. Talk to us about the mistakes that companies make. What do you see maybe too often?
The number one is failure to follow their own procedures. I can't, I see Director Stowe shaking his head. I can't tell you the number of times I've been interviewing the manager and I hear these words, well, it wasn't a formal complaint. And my response is, well, where in your policy does it say what a formal complaint is? It doesn't, right? An oral complaint is a complaint. A written complaint is a complaint. There is no such thing in the law as a formal complaint. The other mistake is a manager receives a complaint and the employee says, but I don't want you to do anything. Well, it's too late. If you're following your procedures, that manager, if they've received a complaint of harassment or discrimination, needs to report it to HR. I think the new Montgomery County statute, the new standard, that's going to be drilled into HR directors, that it has to be brought up the chain. Because if it gets into the agency or into a good plaintiff's attorney, it's going to be a viable case. It's going to be harder to resolve. The other big area are comparators, and the number of times you see companies treating one person differently than another on the same facts. So, you know, that is very difficult to defend when plaintiffs can bring up a number of comparators who were treated completely differently based on the same allegations. And like I said previously, Montgomery County juries are very smart. If you can show the plaintiff was treated one way, but these other two people were not treated that way, their complaints were responded to, action was taken, you're going to be in a very difficult spot as the employer to explain why you didn't follow your policies. And when you don't follow them, that equates to evidence of discrimination, that you're not taking it seriously. And then finally, and this is the easiest to fix. And again, the new standard in Montgomery County should be addressing this with all employers, and that's lack of regular training. It is imperative that employers train on a yearly, every 18 months, some regular basis, so you can use that as a primary defense in any of these cases. The employer's done what they need to do if they can show they have proper policies and trained on them. The number of times we hear people say, I didn't know what to do. You know, yeah, I knew there was a manual, but no one ever told us how it works, et cetera, et cetera. Take away that problem by doing regular training.
Tom, thank you. Cathy, talk to us about the common situation of the consensual relationship, workplace relationship gone bad. How do you deal with the negative attribution?
Yeah, that is a really classic case that I see. Two employees, typically one in a position of power over a subordinate. They have a lovely relationship, and then they break up, and things go really quickly downhill for the former paramour. And I think a lot of women in that situation feel like it's their fault. You know, they never should have had the relationship to begin with. And I think something that's forgotten is those were really the earliest sexual harassment cases that were litigated under Title VII. It's just as much sexual harassment to discriminate against somebody who you used to date and no longer date and want to fire because they're no longer meeting your emotional and romantic needs as it is to discriminate and harass an employee by, you know, hanging up offensive pornography around the office, right? So a lot of people shy away from it because it seems like more of a divorce, you know, a family relations matter than a sexual harassment matter, but it's not. And I like to focus on what happened in the workplace, how that person's treatment changed. You know, what was it like before, while they were in the relationship versus out of the relationship? Were they getting, you know, lots of bonuses beforehand, and then the bonuses ran dry, getting great performance reviews while they were in the relationship, and then all of a sudden they're being put on a performance improvement plan? I mean, that really doesn't look good, especially when the supervisor suddenly gets a new girlfriend in the office and starts giving that person all those perks and benefits. So, you know, again, it's pretty common. You'd think that people would not do that these days, but boy, do they. And it's really sad, and it's really difficult for victims in that circumstance, because they really don't want to lose their employment.
Tom, talk to us about individual defendants. The plaintiff's counsel has drawn up a complaint. They're including not only the company, but individual defendants. How does that complicate your defense of the matter?
It's probably one of the most complicating factors, and I'm amazed I don't see it more often. In the District of Columbia, for example, there is individual liability for managers who are decision makers. So we see it more in DC than I think we do in Maryland and Virginia, but it creates so many obstacles for the defense of the case. And I'll just give you a couple of them. When there's daylight between the company and that individual manager and what their positions are, in other words, they're slightly divergent, you can't represent them both. That individual is going to need their own attorney more likely than not. Number two, once that individual is brought in, whether or not there's going to be if there is insurance coverage for that. Sometimes I've seen carriers deny coverage on the individual claim because it might be tied in with an assault and battery and things of that nature. Now, as the counsel for the employer, you're defending the corporate entity, and you have an employee who may or may not be able to afford an attorney. That can create a huge problem. Third, you're always fighting against the bad actor when you're defending these cases. So if you have a bad actor who's out there on their own on an island without counsel, the company is in a very difficult spot. Of course, these are all fact dependent, to demonstrate they didn't know what was going on. They didn't know what the manager was going. And plaintiff's counsel typically will pull out the bad actor's evaluations. You know, you'll see glowing evaluations, yet there's all these complaints that had been circulating around. It really makes it a harder case to defend for the employer. And the worst case, when it's truly a bad actor, the employer wants to cut ties completely. You may ultimately end up firing that bad actor to separate, cut ties, and then that bad actor is not your friend anymore as counsel for defending the employer. So now they're a defendant in the case. They have no interest in helping the employer because they're at risk as well. And that creates a situation that is very, very difficult to navigate, because you now typically have one of your managers, someone you've promoted up, who's done something, who is the bad actor, so bad that you've cut ties with them. And now the plaintiff's counsel is going to start looking at other things that bad actor may have done, other people who complained about them. And like I said in the beginning, when you have the repeat offender, if you couple that with an individual suit against that manager that drives a wedge between the employer and the manager in the defense of the case, it's not one you want to take in front of a jury.
Cathy, let's talk about the 30B6 deposition or the 412D deposition in Maryland. In a harassment case, you've got some questions you come back to over and over again in your 30B6 list. Give us just a few of those.
Well, typically we want to find out what the employer's policies are, their investigation policies are, if they have any, how they conduct investigations. And then what I always find interesting is, you're supposed to take prompt and remedial action in order to avail yourself of a defense against liability or a partial defense against liability. And what I find most often is there's, sometimes an investigation, but there's rarely a finding of misconduct by the employer. So there's no remedial action taken whatsoever. So that is we usually like to ask a lot of questions whether the employer has ever taken any remedial action, and what remedial actions might they take if there was a finding. And they really usually left with their mouths agape because they never got to that point, because there was never any intention to find any misconduct. And then let's say they did find there was some misconduct in the investigation. Typically, the remedial action is really extremely inadequate. There's separating the employees is maybe done, but it's not effective, or they've separated the employees to the victim's detriment. And typically, of course, never any monetary remediation like restoration of leave or payment of doctor's bills or compensatory damages, all of which I think make up the full panoply of remediation in a matter. So we like to really dig into that from an institutional level in the 30B6 depositions.
Tom, talk to us about after acquired evidence and the discovery process. What are you looking for?
Well, and let me tie this into the new standard. With the new standard being more than a petty slight, trivial inconvenience, or minor annoyance. In order to put on a defense to that, I'm going to have to show to the reasonable juror that these actions didn't rise above a petty slight. I'm also going to have to prove that as to this plaintiff. So my discovery with this standard is going to be more targeted than ever into their social life, their social media life, their texts, their computer at work, probably their computer at home, as far as I can go to get information and evidence to show, or at least have an argument that what happened between the victim and the alleged harasser, whether or not that was really something that upset the alleged victim. Have they engaged in similar banter with others? Have they circulated, inappropriate jokes, inappropriate videos, things of that nature? I'm really gonna, with this standard, want to look hard into that, because it's really, how do you show subjectively that the victim felt the behavior was hostile or abusive? You've got to show what they've engaged in, or what they've done in their own past, perhaps, to try to have any defense on that level. Another thing I'm looking for is inconsistencies. So I want to see, was this employee, was this really so bad that they left the company, or were they looking to leave earlier? So it amazes me how much, and Cathy pointed this out earlier, electronic discovery. It goes on both sides of the V, how important that is and how much information can be found. Maybe the employee was looking to leave before any of the alleged discriminatory or harassing behavior began. Maybe they didn't think much of it as they communicated with their coworkers or other friends. Again, Montgomery County is a very educated jury pool. Common sense applies. And if you can demonstrate to the jury that the alleged victim was engaging in similar behavior with others, I think it's going to go a long way to giving you a defense. Finally, I think we're always looking for, looking at the resumes, the interview process, checking their credentials. Are they real? Did they lie in their application? To give you some argument about damages, the old after acquired evidence. That, believe it or not, still happens in this day and age. You get people who falsify their resumes, say they went to colleges or got degrees or certifications that they didn't get. It amazes me when it happens, but it does happen. And I think if you've got a big damages case, you really got to attack the damages and try to cut them off by any means possible. And that is a very good way to do it if you can dig up evidence like that.
What are some of the common pleading mistakes that you see plaintiffs' counsel making in these types of cases?
The biggest one I see is overreach. You have a number of cases, and I get it. Plaintiffs' counsel wants to load up the complaint with as many causes of action as they can possibly get. But sometimes they have and I'll use retaliation as an example. They have a really strong discrimination case or harassment case. The employer has acted appropriately. They took action. They disciplined the bad actor. They gave accommodation to the alleged victim, right? I often wonder why they want to mess up this great discrimination or harassment case with a much weaker retaliation case, when that weaker case can really call into question the credibility of some of the allegations. If they're really overreaching, just trying to load it up with as many causes of action as they can find, that is something that I think is a problem for plaintiffs' counsel when they overreach, because we can flip it to our advantage and use it to attack credibility of the other allegations. And there's another area in terms of, it's not necessarily pleadings, but discovery. All too often I'll see, I'm always waiting for the constructive discharge. The complaints been filed, the employee's working there, the employer's dealing with it, and then, well, here it comes, that they quit because it was so horrible, right? When I'm going to be able to show the employer did a lot of great things, what I often think is a mistake is for the plaintiff's counsel, unless it's a bad situation for the employee, to encourage their client to leave. Because the worst position for the employer to be in is when that bad actor is still working for you. And you're having to monitor that situation. If the alleged victim is still there, it puts a lot of pressure on the defense, and it really becomes a chess game. You have the litigation going forward, but now we're also playing a chess game with the employee and plaintiff's counsel because the plaintiff is still employed with the employer. And all too often I see that goes away. And I get it, there's valid reasons for it, but when employees stay employed, it makes employers much more willing to negotiate and try to wrap it or resolve it earlier.
Let's move to motions in limine. Tom, what are the 2 or 3 key motions in limine that you're filing pre-trial and harassment case?
This goes back hand in hand with the repeat offender. The biggest motion in limine is trying to cut out all the external noise, prior complaints that a good plaintiff's counsel has uncovered through proper discovery. And the reason I'm trying to knock those out, if they're not related to my case, is because I don't want to be defending in front of a jury my case, as well as 12 other allegations of people who aren't in the courtroom. And I see Cathy smiling because she knows it as well, right? It's a predicament that you get into where it takes your focus off the main case. Juries get confused. They lump it all in together. And they'll use it against you if it's bad enough. So that's one of the areas I really want to try to whittle down. What other evidence of discrimination, harassment, or what other complaints that were made internally can I cut out of my case through a motion in limine? It's hard to do. You can usually connect the dots, but you got to make every effort to knock out those extraneous claims that didn't go anywhere or were resolved internally. Another big one goes into damages. Punitive damages, you want to file a motion in limine in every case, because I don't want plaintiff's counsel having the ability to argue issues about punitives in the opening or during the case. They should have to meet the threshold level if they get by directed verdict on it, then they can discuss it in their closing, et cetera. Or under some federal courts, it's done differently. It's at the very end of the case. But I'm always going to file a motion in limine on punitive damages. I'm always going to file summary judgment on that too, to try to prevent the discovery. And then finally, damages. I want motions in limine on damages if I can get them. Anything I can do to reduce damages or evidence about damages and why the person didn't get reemployed, et cetera, or at a high level or as high a salary, I want to try to attack that as well with motions in limine.
Judge Rubin, if my case has been assigned to track 4, when can I expect motions in limine to be heard by the court?
Certainly no later than the pretrial conference. However, if you get assigned to track 4, you can always ask your trial judge to hear them sooner rather than later, and you can hear them in steps. So it's, in my view, if they're going to be motions for or against either admitting certain evidence for damages or limiting it, to bring it to the trial judge's attention as early as possible, and certainly no later than the pretrial conference. Do not wait until you're in trial to start arguing about all these things with the busy trial judge, because at that point, the judge is worried about the jury. He's not worried about your fascinating arguments about damages. Do all that early. Even if it's not a home run, you might educate the judge or soften the blow for trial. Even if you don't get the damages that you want admitted or excluded, you might get them either narrowed or channeled in a certain direction. But do it early rather than later. Do not wait for the trial, because in our system, the trial judge is going to be focused on other things like running that jury trial and not listening to more esoteric arguments.
Talk to us about motions in limine that maybe you expect to see, especially on experts, that maybe sometimes you don't see.
I would expect in cases like this to see motions in limine, one on the witness's qualifications to talk about particular issues regarding discrimination in employment, including sexual harassment. And another area where I think it's ripe to at least sensitize the trial judge are the bases, factual basis of the witness's testimony. Not the kitchen sink is always not admissible through expert testimony. You might be able to get that narrowed down. And also the external basis upon which the expert relies. Maryland finally adopted Daubert. And I expect to see Daubert challenges in cases like this, as well as more, scientific or mathematical cases. But if you have a motion, bring it early so the judge has time to consider it outside the presence of the jury.
And with experts, there's a nuance there in terms of the relief that plaintiff
Yes.
or defendant should be seeking that you're not seeing all the time.
Scott, I'm glad you reminded me of that. Typically lawyers, because I guess that's the nature of how either I was or we all are, always swing for the fences and say you want to exclude and eliminate an expert completely. There might be lesser or smaller forms of relief that you might be able to ask for and get. Judges are typically reluctant, especially early on, to toss completely one side's expert or to allow completely one side's evidence about damage, but they might be willing to narrow it. So if all you ask for is a home run, the judge could say no. But if you ask for a single or a double, you might get it. But if you don't ask for it, I can't give it to you. I can't give you something you didn't ask for. And if you only ask me for a home run, even if I think you're entitled to a single, I'm not going to give it to you because I'm lawyering the case and we're not going to do that. So you have to ask for lesser relief if it's appropriate.
Cathy, let's move to voir dire for a moment. Maybe a few questions that you are asking the judge to put out there with a venire. Give us a couple that are on your list.
Well, I want to know about whether someone has ever been involved in a harassment matter, either as a witness, victim, or alleged perpetrator. That's important to know. I want to know if someone's ever been involved in any kind of discrimination case, one way or the other. And, I'm like real light on voir dire because I always get denied. Whenever I'm asking for interesting questions, they always get bounced anyway. So I've learned to keep them really basic. And that's really what I want to know. What are people's experience with these things? Do they have a family member who went through this harassment, some kind of harassment matter? I mean, I just think, every woman in America and probably every man in America has had some experience with harassment in one way or the other, right? As a witness, as a victim, as a perpetrator. So it's not necessarily a reason to exclude someone from a jury, but it's something I definitely want to know.
Tom, how about you? The 2 or 3 questions that are always on your list in a harassment case.
Well, agree with Cathy completely on the first one. Has the juror ever been a victim of, been involved in, or have any family members or close friends who have been involved in a matter of sexual harassment? And keep in mind, it could be the person's spouse, significant other, sibling, friend who went through an experience that was detrimental to them. You need to know that, and you need to determine how involved this potential juror was in it. Most certainly, if they were the accused or a victim, you really got to know that. And that may be a strike you get the court to give you rather than using your own, but you certainly have to know it about their involvement. And I would go broader to any discrimination claim. Even if I'm trying the sexual harassment case, I would take it broader to any type of discrimination claim. Have they ever been involved in one? Another, a question I have not had a chance to use yet, but I will try. And it comes about because of the Me Too movement. And what we see in the press all the time, we see it from our politicians, celebrities, et cetera. And that is, do you believe that any person who claims sexual harassment should automatically be believed? And I don't know if the judge will let me ask it. I don't know if it'll get stricken like Cathy was saying, but that phrase is so embedded now in our everyday lives. You know, you've got to believe the victim. You've got to believe what they said. I think it's a fair question to try to show if there's bias, that they're already going to believe the plaintiff as opposed to the company or the accused harasser right from the start. Has that gotten so into their psyche from media and press and everything else that that's what they think the standard is? I want to know that.
Judge Rubin, some advice for lawyers on the most effective use of judge-led voir dire in Montgomery County Circuit Court.
Sure, Scott, a couple of things. As you know, in Maryland, the judge does the voir dire. The lawyers have very little ordinarily to do with it, but there are some opportunities. One is regarding the questions. I'm always amazed that lawyers don't remember that in addition to the questions, form questions by the state bar, most federal circuit courts of appeal have form voir dires that have been adopted by federal appellate courts. So if you come to me saying, look, the Seventh Circuit and the Sixth Circuit and the Eighth Circuit allow this, that's great, as opposed to saying, I just want this question because I want it. There is authority out there that folks are neglecting to use, because most of the decisions by my Court of Appeals on a criminal case is totally different fact patterns, don't have anything to do with cases like this, but it's out there, so you can bring it in. The second thing is when the judge will give you an opportunity to follow up with a prospective juror at the bench, if you can get that person to talk, while you can't usually lead them into admitting that they're prejudiced, if you can keep the person at the bench talking long enough, if there's prejudice, it will pop out. So don't do the testifying for the potential veneerman, but if you prod them to keep going, people, once they start talking, it's hard to shut them up in Montgomery County. So that prejudice, if it's there, is going to pop out. So let it happen, and don't not take that opportunity. You know, there's a tension between the judges. We want to put a jury in the box. We want to get it done. Counsel are not in that kind of a rush, and we get that. So there's that fine tension. So if there's a juror that you're worried about, ask to approach the bench, ask to have that juror come to the bench and talk to counsel and the judge and see, like in a Batson challenge in a criminal case, you can get that prejudice to pop out. Because if you're good enough, and you are, if you nudge that person along, it'll show up after a couple of minutes. And lawyers, for whatever reason, don't do that. They just want to get it over with. That's the biggest mistake. In my opinion, cases probably won or lost after you pick that jury. That's just my opinion.
Point of view questions, experience and the like, how are those best put with jurors, you know, when they're with the husher on and they're up with you with counsel?
Well, I mean, based on what I've seen, you want to find out if there's anything that's giving that potential juror discomfort about sitting in this case. If you ask them specific questions, people are going to say, no, I'm fine, I'm fine, I'm fine. But if you make it open-ended and let them define what's turning their tummy upside down, they'll tell you. But if you try to put words in their mouth, they're going to say, no, I'm fine. Just, you know, like asking someone, did you do that? No, I've never done that. Well, tell me what happened. They'll tell you what happened, and then you'll find out that they did it. But if you ask them if they did it, they'll say, no, I didn't do that. Open-ended, let them talk. You'll figure it'll show up.
How can lawyers best address damages in voir dire?
Typically, lawyers don't, in my experience, don't pay a lot of attention to damages during the voir dire process. you need to find out whether there's anything in that person's life experience that's going to make them think that your dollars are big or small. Everybody will tell you that they can be fair. Everybody will tell you they can award damages in an appropriate amount. But you should ask them, is $1 million a lot of money to you? Some people say in Montgomery County, no, it's about average. Or find out what's big to them. You know, making a lot of money, you've got to let them define what that means. And find out on Weiser, because you could have a great case and then you get $5 and you go, where did I try this case for? Figure it out at the beginning. They'll tell you if you ask them.
Research on prospective jurors, social media, maybe the other background issues. You have some advice about that.
This is something that I go back and forth on in my own mind. You know, from my point of view, what I worry about, if jurors know or think they're going to get investigated by the lawyers, they're not going to be willing to serve. I've heard the argument make, well, listen, they put it out there on social media, it's fair game. That's true to a point. But if you told a prospective juror, you know that if you sit on this jury, the lawyers for both sides are going to investigate you up one side, down the other. Assume it's the FBI and the IRS combined. People will figure out ways to not be on the jury. So I used to think it was fair game, but I'm coming around to worrying about, are we going to get qualified jurors if they're worried about, is my life going to be investigated by these people? I didn't do anything wrong. Why am I suddenly on trial? Now, that's from a judicial point of view. I could see the lawyers taking a different point of view. I don't think it's, you know, it's not binary is where I'm coming out. It's not such an easy call. And since it's not a criminal case where a lawyer could say, I've got the right and bang the Sixth Amendment, Fifth Amendment through the 14th is probably a little softer about your quote unquote right to investigate the potential juror. But it's going to develop, and we don't have a lot of guidance in our appellate cases yet. I'm sure it will happen.
Let's move to opening statement. Tom, what are the most important themes in opening statement before a Montgomery County jury from your perspective?
Well, as I said in the beginning, Montgomery County juries are highly educated. And with that, I like to focus on common sense. I mean, my answer is going to be, you know, specific to cases, but generally speaking, I want the jurors to focus on common sense as they view the evidence that's coming in. Not everybody's perfect. My client's certainly not perfect. The alleged harasser's not perfect, but put your common sense goggles on as you hear the evidence coming in. And certainly listen to all the evidence. Secondly, if I have a case that I know I'm going to be able to show inconsistencies in the plaintiff's story, what they claim happened or how it impacted them, et cetera, I'm going to raise that in opening. I want the jury to be looking, listening for these inconsistencies that are going to come in. I will only do that if I have a document, deposition testimony, or a witness who's really going to nail it, because you never want to promise and not give the jury what you promised them. But inconsistencies are a big issue that I want to alert the jury to be looking out for. Representing companies, representing the alleged harasser, I want to humanize them, particularly the corporate entity. I want to get information in about what they do in the community. I want the jury to understand this corporate entity represents people, that they do a lot of good things, they're involved, et cetera. And that goes for nonprofits and for-profits. You want the jury to understand who they are and what they do. That's something that I think is not done enough, particularly when you have a huge corporation that you're defending. People have their own views of the Fortune 500s. And you may not ever be able to shake those views if they're negative, but you can humanize the corporate entity by talking about their philanthropic work, the charitable work, et cetera. Finally, and again, depends on the case, but I usually, by the time we're at trial, I have a pretty good idea what the plaintiff's going to hammer me with in their opening. The secrets are all out for the most part. if I have something that can really undercut what I believe is going to be the plaintiff's theme or a critical part of their case, and it's an exhibit that we've agreed is coming into evidence, or I've gotten that approved already before, I'm going to use that piece of evidence in opening to show the jury, to try to plant the seed at opening that what plaintiff's counsel is telling you this case is about, it's not really about that, or there's a significant dispute about it. But you got to have the right piece of evidence, and you got to deliver it when the time comes. Those are my major, generally speaking, major themes I look for.
Judge Rubin, the hallmark of an opening statement, you've seen a lot of them. Give us some insight.
To me, the opening statement is telling a story to the jury. And lawyers, in my experience, sometimes waste too much time introducing themselves, where they went to law school, all their jobs. Nobody cares about that. The jurors don't care about that. The jurors want to know, what's this case about? What's the story? Lawyers need to be good storytellers. You need to have the beginning, the middle, and the end, and you've got to bring the jury along with you. It's not Hollywood per se, but jurors expect some modicum of entertainment. They don't want to hear cut, dry, boring statistics. They'll zone out, their eyes will close. If you have demonstrative evidence and it can be done professionally to help them lead you through the story, that's great. People are so used to looking at their computers, everything is visual. Even when we go to judicial training, there's this PowerPoint and all this stuff. In the old days, it was just lectures, and we would listen and we would learn. These days, the best lawyers entertain the jurors, not only with their words, but with pictures. And if you're going to have demonstratives, make them as professional as possible. Jurors wince when the lawyers get up there with a whiteboard or a black piece of paper and band handwriting and start writing things down. People can't see it. It's too small. The letters are wrong. If you're going to do it, make it professional. Otherwise, you diminish your effectiveness. And if you're going to take a case to trial, there's no reason not to turn it into, it's your Broadway production, make it sing or stay home. That's my opinion.
Judge Rubin, thank you. Cathy, let's move to case in chief. And you like to put your client on first. Tell us why.
Well, taking off from what Judge Rubin said, trials can be so disjointed, right? So, you have this person on for this piece and this person on for that piece, and it can be very confusing to a jury unless, as Judge Rubin said, you've already set the stage, you've told the story, you're telling them what to expect. I've always, as a prosecutor, I was told, tell them what you're going to tell them, then tell them what you're going to tell them, and then tell them what you're going to tell them again. And, you do it 3 times and you're all set. And so you want to, sometimes putting the plaintiff on first is very helpful, because then you can get the whole story out in the beginning. And then the rest of the trial, usually the jury will fall asleep until the perpetrator gets on, because your client has already convinced them as what's happened, what the whole story, and then everybody else sort of corroborates it. There are situations where you might not want to do that, but typically I would. I have to go back, though, to what Tom suggested about his new possible voir dire question and say, if that were proposed, I would have to come back and say, well, I want to ask all the jurors, do you subscribe to the age-old adage that a woman, his outfit means she was asking for it? I mean, I'd want to go through every stereotype that's anti-victim to see if the people, if the jurors had those stereotypical attitudes as well. So whereas, Me Too may be new, there's a lot of sexist attitudes that are out there that have been around for a lot longer that we'd want to make sure the jurors aren't holding. So my guess is if Tom suggested that and then I suggested mine, the judge would say, forget it. We're not having any of those questions. We're going back to where people live, their address, and work with that. So anyway, it's just my 2 cents.
Cathy, thank you. Judge Rubin, talk to us about the use of video in a case in chief in particular. What have you seen where it's been effectively used?
I've seen some counsel be extremely effective with using video clips from depositions that were taken during the case. If they can find a 15, 20, 30-second segment where it shows the other side's witness looking like a horse is behind, that image is going to stick with the jury. Look, it's a lot of work, but I've seen lawyers do it very effectively. Most of these cases are discovery heavy. You're probably going to video some of the witnesses. If you got a nice video clip out of that, that you can use it in opening, and use it early and use it often. You got to get the jury's attention in the beginning. Don't say, I'll get to them on day 3. By day 3, if you don't have them, you've lost them, regardless of what side you're on. Use it.
Judge Rubin, you allow interim argument. Tell us what it is.
I have, and it's a technique rarely asked for, and if you don't ask, you won't get it. But I've had lawyers want to argue before, after opening, and before summation on particular points. And these cases are relatively complicated, and the new standard is going to give us some fodder for jury instructions and what's admissible. Ask for interim argument if you've got particular points to make. And tell the judge, look, I only want 2 minutes. 2 minutes for me, 2 minutes for my opponent. But if there's something you want to hammer home before summation, ask for it. I've allowed it. I don't know why people don't ask for it, but why not? I used to do it.
Juror notebooks. When have you seen them? First off, when do you allow them, and how are they most effectively used during a trial?
I've seen counsel, particularly in MWELA cases, effectively use juror notebooks to have the jury buy into their hymnal. They prepare a juror notebook for each juror. It's going to contain only documents that are clearly admissible. And they ask the court permission, can the jurors keep this during the whole trial? And can they keep their notes in the notebook as opposed to on those little pads? And can they take them back to the jury room? So then you've given the juror your hymnal, they put their notes on it, they take it back to the jury room, you're halfway there. Now, both sides can do that. You can have a jury notebook where there's agreed exhibits, but give the jurors something to work with during the trial. Don't make them go back at the end and go through the 12 stacks of documents and hopefully find the right one. Give them something they can hold on to during the trial. It also tells the jury you care about them, you're trying to make their lives easier, and here's the important stuff, and keep your notes in it. That's what I would recommend, and I've seen lawyers do it very effectively.
And this is a subset of the exhibits, not all the binders of exhibits.
Right, it's the so-called hot documents, key exhibits, the top 10, and usually counsel can agree on it. But if you can say, judges, there's 5 documents, I want them to keep them with them, judge might let you. I can't speak for every colleague on the bench, and some judges might say, no, let them sort through the box at the end. Doesn't hurt to ask. And if you give a judge an idea and say, well, this is the reason why I want to do it, the judge very well may let you. You've lost nothing. You may have gained a juror or 2 in the process.
Tom, let's talk about damages witnesses. Who are the kind of mental anguish damages witnesses that concern you most on the defense side?
The ones that concern me most, it's not the plaintiff. It's the spouse, the significant other, the child, or a longtime mentor, say from their prior work life. Those witnesses, in my experience, they can tell the story that the plaintiff may not be able to tell as effectively. The plaintiff has been through the trial, they've been through a lot. Jurors will listen to that and they'll weigh that testimony. But when you bring in a third party who has testimony about what they witnessed this did to the plaintiff and how it impacted them and their firsthand experience with that, and particularly if it's like a teenager or 20-something, a younger person talking about their parent and what they went through, it's very effective for plaintiffs. I often wonder why I don't see more of it, because it's particularly hard to cross-examine that third party. All they're talking about is what they witnessed. Your hands are really tied trying to attack what they witnessed and how it impacted them. So I think those are the most effective pain and suffering, et cetera, witnesses that plaintiffs can put on.
Judge Rubin objecting at trial. What's your advice?
Well, my advice is obviously object if you need to protect the record or it's really important. But if you're not really going to be able to keep something out, and I would handle the big evidentiary issues before trial. The biggest thing I've seen lawyers do that has helped them is to say, I could object to that, but I don't care, let it in. And unless it really hurts you, or you must preserve it for appellate review, the jury, you don't want the jury to view you as an obstructionist as a lawyer. Jurors want to get to the truth. They want to do the right thing. They want to be fair. If you are, even if you're not, if you're perceived by the jury as an obstructionist, it's going to hurt you. I mean, remember, to the jurors, it's not a test on the rules of evidence. You're not going to get it. You might get an A with the judge, but you might get an F with the jury. And remember your audience. And it's a careful balance between the jury and the appellate court. I get that. And if you're going to do it, come to the bench. Don't do it in front of the jury, because then just the judge sees it. But control your body language when you're objecting. No rolling of the eyes, no guffawing. And sometimes it's hard, especially when you're tired. It's a long trial. It's a long day. But the jurors watch that stuff. And even when you're at the bench, while they can't hear you, they're watching you. So just be neutral. And then when the day is over, let your feelings out, but not when the jury's in the room. Or ask the judge to send the jury out if you want to have at it with the other side. That can be better, and duke it out, but not in front of the jury.
Tom, you use a very effective looping technique on cross-examination at times. When do you choose to use it?
I use that when I know I have the witness where they've said something or done something that I have evidence of that I can use to refute what they've been up there testifying about. That sounds simplistic, but what I mean, and this goes to something Judge Rubin pointed out, the most effective way to do it is when you have videotape deposition testimony, electronically recorded with the transcript in the lower half. And we use that all the time. Scott, I know you use it all the time as well. If you have that 30-second clip of that witness testifying in a way that's different than that they've just testified on the stand, I will loop back to what they said on the stand. I will loop back to what they said in their interrogatories. I'll loop back to any other evidence I have of them taking that position, and then let them dig their own grave, so to speak, and then I'll hit them with that strong piece of evidence. But it's got to be strong. And if you have that videotaped deposition with the transcript below, it's in that witness's own words that they're now contradicting what they said on the stand. In my experience, that can be devastating. But it's got to be a good contradiction. It can't be gray. It's got to be a strong one.
Sometimes plaintiff's counsel struggles with their rebuttal case, Tom, after you put on your case in chief. What, from your perspective, what's the most effective rebuttal case for a plaintiff in an employment case?
It's along the lines of what I just discussed. The most effective rebuttal that has been used against me is a witness who directly attacks our main claims and leaves the jury with the impression that we have not been forthright, or there's still a dispute. There's something that's in dispute, and now you're walking out of that courtroom. The jury's going to retire, and the last impression they have is that my client wasn't honest. So I think the worst rebuttal is when they throw up a rebuttal witness that nobody understands. It's like, what was that for? I don't get what that was about. But if you've got a strong one that attacks the primary defenses or the credibility of one of the main witnesses, put that person on in rebuttal and let that be the last thing the jury hears. I think that's incredibly effective.
Let's turn to closing argument. Judge Rubin, should the plaintiff identify a number that they're asking for with specificity with the jury?
That's, of course, a professional judgment that each plaintiff's counsel or defense counsel has to make. From my vantage point, I've seen lawyers wish they had asked the jury for a specific number, because just asking the jury to do what they think is right or what they think is fair, is you might be stunned as to what they think is fair. They might think $10 is a very fair number. You just didn't know that. You counsel have put so much time into getting the case ready and trying it. If you have the courage of your convictions, tell the jurors what you want and why you want it, and be blunt with them. Don't leave it sort of fuzzy like it's that topic nobody wants to talk about when mom and dad are in the room. Just say, this is what we want and why. I mean, that's just my opinion. I know there's lots of schools of thought, but I've seen lawyers be very unhappy. They've gotten all the right answers on the verdict sheet except a very small number, and they didn't ask for a big number or the right number, whatever it is. They left it to chance. In other words, don't leave it to chance. It's an important case. You spent a lot of time. If you're serious, put it out there and just ask for it. That's what I would do.
So I'm going to turn to final thoughts in just a minute. Before I do, you mentioned verdict sheets, Judge Rubin. Advice for counsel on verdict sheets?
You know, in these cases, especially with a new statute, we, the judiciary, are going to need lots of help in crafting a verdict sheet. So the first thing is, don't wait till the trial is about to be over and the judge is trying to rush getting the jury out to deliberate. Start working on that verdict sheet before you pick the jury, and bring drafts to the judge's attention early in the case. Because in cases like this with a new statute, what the sheet should look like is going to be a subject of a lot of debate. One side's going to want very few questions. One side's going to want a lot of questions. All that's fine, but that's an important thing to do very early and in stages. It's not one and done. And do not wait to the last minute, because likely the judge is going to be distracted, the jury is going to be tired, and it's going to be a less than perfect verdict sheet. Very important. Cases are won or lost on the verdict sheet, in my opinion.
I know that we have a ton of questions. There's no way we can get to all of these. So here's what we're going to do. I will make sure that we get answers to every one of you that have asked the questions on the Q&A. We'll do that separately by email. Now I want to turn to final thoughts, and I want to begin with Jim Stowe. Jim, final thoughts for us?
A couple of areas. I think that, Tom, I don't know if this is an area that you might agree with or not, but we're finding that particularly for those who are representing respondents, one of the areas that we are finding, and particularly a few complaints we've had recently, is that the actual violation is coming from the top of the organization. It's sometimes in the executive suite. And I suspect that makes it even more complicated as to how it gets handled. And the other area that I think is really something that's often not looked at is that the culture and the actual practice of the work environment. While it's not necessarily part of the actual day-to-day 9-to-5 kind of activities, it does relate then to a lot of business decisions being actually decided upon, mentoring going on that takes place in those environments, as an example. And what I'm talking about basically is that every Friday at 4 o'clock, the men do this. They go and they go away and they golf or whatever the case may be, and don't invite necessarily the brand new promoted female member of the executive team, as an example. Well, a lot of decisions get made in that golf course, as an example. A lot of things are talked about. A lot of opportunities are missed, as an example, because she, in this case, she's not there. And I remember a case very recently where, and I'm talking about it was surprising that again, that a senior level person, in this case, the president of the company, did not in fact practice what it was that they had in terms of their policies on this issue of harassment. And so it really is a situation where we're trying to encourage persons just to make real sure that you in fact are leading in a way that not only shows a great example of what you're talking about, but clearly when there's issues that you're engaged in, that you clear those matters up ASAP. We're also suggesting then that persons are engaged in training. That was mentioned a couple of times by Ms. Harris. But I think it's important that training take place as well as Tom, I think you mentioned it too. Not only in a situation where there's regular training, but I'm suggesting that it also occur in ways then that it is always pertinent to and pertaining to what's going on in the moment. If you're dragging out the training that you did 10 years ago, that's not very relevant to what's happening right now. And I think a lot of people are, in fact, depend upon that, unfortunately, and find themselves in a lot of trouble as a result of all that. So we recommend strongly those things take place as part of the process. To attorneys out there, we would love to be able to work with you directly. We want to become a resource to the bar and those who engage in that process. At the same time, we have obviously are there for those who are complainants as well. And we believe that we, in fact, can create good law when we work together on these things. It does not have to be an adversarial kind of relationship. We're not looking for that. We are trying to obviously enforce the law as it dictates in Montgomery County. So we would hope then that as we talk about issues of responses from you, that they are timely, that we can depend upon you doing that. And if you are asking for extensions, that they're reasonable. We try to work with folks in as far as that is concerned. But keep that in mind that we are trying to deal with a fairly large caseload for a small staff. And so we hope then that you would adhere to those timeframes as best you possibly can. And if there are questions and concerns, we're not perfect by no means. And so we're there trying to improve. And if there are areas for which you think that we can do a better job, we certainly appreciate and we'll certainly receive those kind of suggestions and recommendations. At the same time, and know then that we're trying our very, very best to be as comprehensive and as thorough as we possibly can in our investigation and render a finding that is fair and in direct relationship to the law itself. And so those would be things that I would share with you, Scott. Thank you again for allowing us to be a part of this discussion. And we look forward to doing more things with the bar going forward and look forward to that opportunity in short order.
Jim, thank you. Cathy, final thoughts.
Yeah, so far nobody's yelled at me for getting this law passed, so I'm really thankful about that from this panel. I'm really encouraged to have a new standard in Montgomery County. And, my understanding is other jurisdictions are going to begin to adopt these as well. The Maryland Senate was considering it. And so we're going to be seeing this loosening of the standard, not just in Montgomery County, but in other jurisdictions as well. And as practitioners, we're the ones who are going to have to start interpreting it and helping move it along. I think it's going to help workers. I think it's going to help workers get better relief sooner and prevent damage, prevent really severe damage if people do take advantage of filing under the new lesser standard. And that's what I'm looking forward to. So thanks again, Scott, for having me on, and appreciate you putting this panel together.
You're welcome. Tom, final thoughts.
Yes, I'm going to echo what Director Stowe said. This is a new world order now in Montgomery County. And as Cathy said, it's very likely coming to other jurisdictions. This lesser standard makes training more important than ever. And to have an employee say, oh, I didn't realize that could be a problem. It is a problem now under this lesser standard. And without the training, people aren't going to know, the employees aren't going to know, and claims are going to come. Secondly, with the new standard, we're going to be creating new law. The agency is going to be creating new law. Cathy is going to, and I are be creating new law, and you, Scott, and Judge Rubin, you will be too, as we interpret this statute. No one knows where it's going to go, but it is going to be interpreted. And, just like your client never wants you to hear your lawyer say, that's a really unique issue you have, right? This is a really unique issue because it is a standard no one's dealt with. And more importantly, how's a juror going to hear it and interpret it? If you think of severe and pervasive, which is the Title VII, the prior standard, that there's a full body of case law about what that means. Trivial slight minor inconvenience, was it just that? Those terms don't have legal meaning yet. So training your people, training everyone in the workplace, and as Director Stowe said, all the way to the top. Because if you've got the head of the company doing something that is offending someone under this lower standard, everyone's fair game. And it's going to, even if it's not a claim, it's going to come in as evidence of the corporate culture, as Director Stowe indicated. So those would be my final thoughts as we go into this new frontier with the new standard.
Tom, thank you. Judge Rubin, our final word.
Just briefly, because I know the hour's late. I think the bench would be welcome everyone's help with crafting jury instructions for our new statute. We're just not going to be able to simply read the statute to the jury because the statute's not written that way. So if the bar and various committees of the bar can start work on model instructions, that would be very helpful to us because, we can't just read the statute to the jury. So that's where I see the work where you could help us help you is on jury instructions. And Scott, thank you for your time.
You're welcome. Judge Rubin, thank you. Cathy Harris, Tom McCally, Jen Stowe, we are grateful for your time today. For future programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. That's it for us today. We look forward to seeing you next time.